Welcome to The Week That Was, TIOL's weekly news roundup. Today we bring you developments on Delhi's odd-even formula front, as well as stories from the courts indicating efforts by the judiciary to rein in the government.
There are also stories on the impact of the internet revolution as well as pre-budget demands from organization. But first, let's hear the future about the odd and even formula.
What has been the response to the odd-even formula? While most of Delhi is stoically adapting to the odd and even car formula to do their bit for the environment, the Supreme Court Chief Justice and judges, otherwise exempt from the rule, are setting an example by carpooling in a staff car, taking a metro ride, or even riding bicycles to work. However, few obstinate exceptions have not taken the scheme too well and challenged it before the Delhi High Court. A batch of petitions before the court have questioned the scheme and the hefty Rs 2,000 fine imposed by the government without making any amendment to the Motor Vehicles Act. So even as the Delhi government defended the scheme by its impact on traffic congestion and the level of air pollution in the city, the Delhi High Court was not convinced. It has observed that the curbs are an inconvenience to the public as the transport system is inadequate and commuters are facing difficulties, with a long wait for the bus or even auto drivers either refusing to ply or charging twice as much. The High Court has directed the Delhi government to justify the scheme by demanding details on air pollution levels during the week the plan has been in effect. It has also sought to know the extent of pollution caused by the taxis, which have been kept out of the purview of the odd-even formula, as well as details of infrastructure in public transport for persons with disability. It has asked the Delhi government to reconsider its decision on keeping lawyers out of the exemption list. So now, even though the Delhi government has declared the formula successful in reducing traffic congestion, the High Court has suggested that the government wrap up the odd-even experiment in a week rather than in a fortnight as planned. We shall keep you posted. Who must have the final say in quasi-judicial appointments? The state or the judiciary? Let's find out from Maneet.
Should the state government have a say in the appointment of the head of a judicial tribunal? The Gujarat government had appealed before the Apex Court against the High Court ruling that sought to eliminate the role of the government in the appointments process. The Apex Court has now agreed to consider the issue but directed the Gujarat government to first make the State Cooperative Tribunal functional by appointing the president and judicial member as per the names suggested by the Chief Justice of the court. As per the statute, the Chief Justice of the court sends a short list of names of retired judicial officers of the state government, which then selected 2 names from this list. However, the Gujarat High Court ruled that this process does not reflect the primacy the Chief Justice deserves in making the selection. Hence, it ordered that the state government was bound to approve the appointment of the 2 names as selected by the Chief Justice. However, if it had serious objections, then it could approach the Chief Justice for a fresh name. Can the judiciary alter the consultation process for such appointments? The Gujarat government thinks not, and the tussle continues. There has been some tough consequences since the Supreme Court has squashed the NJAC. Let's go to Asha.
Justice delayed is justice denied. But this maxim has taken a back seat even as the tug of war between the judiciary and the executive has halted the appointment process for the selection and appointment of judges. The number of judicial vacancies has increased and there is a higher pendency of cases. All efforts by the judiciary to speed up the disposal of cases have come to naught as there are 45 lakh cases pending in the high courts, which may cross 1 crore by the end of this year. Currently, 24 high courts in the country are functioning with 43% of vacancies. There are only 599 judges as against a sanctioned strength of 1,044. Even the Supreme Court has 5 vacancies and a pendency of 60,000 cases. The trial courts have nearly 3 crore cases pending. The pendency in the courts is expected to increase to 4 crore by the end of this year if the vacancies are not filled up fast. The present status quo is an outcome of the Supreme Court clipping the role of the government in the appointment of judges by scrapping the validity of the National Judicial Appointments Commission and reviving the collegium system. This process is, however, yet to operate as the centre has not yet finalized the Memorandum of Procedure for selection of High Court and Supreme Court judges in consultation with the Chief Justice of India. The centre wants to push for merit over seniority, which could lead to some heartburn among the Chief Justices of the High Courts who get appointed as judges of the Supreme Court. The centre also wants to broad-base the process by allowing all judges to suggest names of advocates and district judges who they consider outstanding. Those who expose corruption in government, will they get protection? Let's find out.
The Whistleblowers Protection Law has been pending in Parliament for years, even as governments only seem to come down heavily against corruption. But now, the Supreme Court has stepped in to direct the government to put an administrative mechanism in place for the protection of whistleblowers as they face threats and harassment for showing up the irregularities in government departments. Within a week, the government will need to spell out the steps it intends to take for their protection as well as the time frame within which it shall do so. As the Supreme Court mentioned, whistleblowers exposing corruption is a global phenomenon and has become a reality in India too. Whistleblowers cannot be wished away. Supreme Court was hearing the public interest litigation filed by an NGO for an effective whistleblowers protection program. The court, however, refused to examine the amendments proposed by the government in the Whistleblowers Protection Act as the law has not been passed yet. It is feared that these amendments, if implemented, could destroy the intention of the law by not allowing anti-corruption crusaders to reveal any documents classified under the Official Secrets Act. Policy implementation is all about teamwork. Let's see what's happening on the gold front.
To streamline the implementation of gold policy and create the missing coordination between the decision-making bodies, the government has proposed to set up a national gold board. Consider this. Bullion decisions are taken by the Directorate General of Foreign Trade, the Reserve Bank of India, and the Customs Department. So when the government restricted gold imports, there was a distinct lack of coordination between these bodies. Even the recently launched gold monetization scheme is yet to take off for want of clarifications. A national gold board, expected to be announced in Budget 2016, will help manage imports, encourage exports, and drive the development of infrastructure. The gold board would comprise of representatives from government agencies, the ministry, and RBI, among others. Have you prepared your wish list for Budget 2016? Well, others have. Let's find out.
Stepping into the new year also means the budget is around the corner, and organizations are drawing up their list of pre-budget recommendations. In its list of demands from Budget 2016, the National Association for Software and Services Companies, or NASSCOM, has asked the Finance Ministry to exempt startups from direct and indirect taxes, including even the minimum alternative tax, in order to reduce the compliance burden and cash outflows. NASSCOM even wants the angel tax to be removed. This demand was made last year too, as the tax hurts the startups that need angel investment when financing from banks and venture capital funds is unavailable. NASSCOM also wants the government to exempt capital gain tax on income from sales of startups if they are then reinvested in securities of new startups. Now that's a list. Are PAN cards being responsibly issued? Let's go to Asha and find out.
The PAN card, widely accepted as evidence of identity and address, is an important document and needs to be responsibly issued. But that does not happen all the time. The Bombay High Court has pulled up senior central government officials for issuing a PAN card to a foreign national claiming to be an Indian citizen. This foreign national, one Mr. Faisal Issa Yusuf, also went on to open bank accounts with 2 banks. He has even acquired properties in India. The High Court has summoned senior government officials to apprise the court of the action taken. The High Court threatened to issue contempt notices against these officers as no inquiry has been held on how the PAN card was issued.
Now for some internet news on the entertainment front.
Netflix, the world's popular video streaming service, has come to India. Starting with viewing plans as low as Rs 500 per month, Netflix allows users to watch movies and TV shows across screens on tablets, laptops, mobile phones, smart televisions, and even PlayStations. The first month is free and payments may be made online quite speedily. While Netflix has some independent content, it may soon be adding some Indian content by tying up with Indian partners. In spite of lower internet speeds, the video streaming is expected to be smooth after a few seconds of initial buffering. Will India welcome Netflix?
What are the dodgy trends on the internet?
The internet has surely pervaded every aspect of human life, even the most private. Now we have an app that allows socially inhibited single users to romantically connect with other single users. Tinder, the popular location-based mobile dating app, has now set up shop in India. This makes India its first international office outside USA, even though the Tinder app already works in 196 countries and is among the top lifestyle apps in more than 70 countries. The company has appointed a Harvard MBA graduate, Ms. Taru Kapoor, as head of its India operations in Delhi. The focus is on establishing the brand in India, increasing user base and engagement. For the uninitiated, registration on the Tinder app allows you to see photos of other singles based on your preferences. You swipe left if you don't like them and swipe right if you do. If someone also swiped right on your pic, the app informs you it's a match and pushes you to begin chatting online, perhaps leading to a hookup. Launched in 2012, it registered 1 billion swipes per day within 2 years. Tinder plans to make India its core market.
And now for some somber news.
A legendary legal luminary is no more. Former Chief Justice Mr. Sarosh Homi Kapadia, 68, passed away this week in Mumbai, leaving behind a legacy of discipline and integrity. Discipline that enabled him to rise from a humble clerk to the highest echelons of the judiciary, and integrity which was reflected in his personal demeanor and each of his judgments. Born into a poor Parsi family soon after India's independence, he worked at a law firm, delivering briefs to solicitors and lawyers. He went on to study law formally and became a lawyer. His eagerness to learn, his ability to instantly grasp the core of the matter, and brilliant expression made him a much sought-after lawyer. His intense defense of the poor and marginalized people of a Mumbai suburb saved them from eviction. He was known to put his heart and soul into any matter, even if it was being done gratis. His work ethics, perseverance, and integrity propelled him from the position of a judge in the Bombay High Court to Chief Justice of the Uttaranchal High Court to the Supreme Court, where he presided over the much-dreaded tax bench throughout his tenure. He had mastered the subject and went on to deliver many landmark verdicts, including the Vodafone International decision on treaty shopping, the Morgan Stanley judgment on transfer pricing, and the Enron case on production sharing contracts, and many others. Another landmark judgment was the 5-judge bench ruling in the media trial. He was one of the biggest influences on Indian tax law. After retirement in September 2012, he did not take up any government post but worked in his Mumbai office. He advocated institutional integrity, a minimum standard of fairness as the single largest stimulant for economic growth, and recommended changes in the Model Code of Conduct to emphasize duty to the country as a core objective for professionals. India and the legal profession have indeed lost a noble soul. On this note, we conclude this bulletin of the week that was.
Thank you for watching, and you may write to us at editor@tiol.in. Have a wonderful weekend ahead.